So yesterday was quite the day as far as Supreme Court proceedings go. We got several different decisions announced, including a few non-decisions, that is to say where the court's saying we're not going to take up these particular cases. And some significant matters were before the court. Gun rights issues, police qualified immunity, and of course the one that did yield a decision, yesterday's Bostock case, which deals with LGBTQ discrimination in the workplace. Let's talk about these three matters with the director of the Center for Constitutional Studies at the Cato Institute, Ilya Shapiro, who I'm so pleased to welcome to the show today. Ilya, welcome to the program, my friend. Good to have you.
Good to be on, Jimmy. I was convinced by your ad. Could I get a complimentary Crossroads Club membership?
Let me think about that, but I'd much rather you go ahead, take the initiative, and sign up yourself, Ilya. So let's talk for a moment and start with the one that has really garnered the most attention, I think, of late, and that is this Bostock decision. Tell us about the basic facts of the matter and what this case was about and the overall decision. Then we're going to dive into some of the particulars.
So these are three cases. Bostock happens to be the one with the lowest case number. That's why the decision is based on that. But basically, people who are fired from their job in the private sector because they are gay or, in one case, transgender. And the issue is it's not a constitutional rights case. This is Title VII of the Civil Rights Act of 1964, which prohibits in relevant part discrimination in employment decisions on the basis of or because of sex. So the whole issue here is whether because of sex includes because of sexual orientation or because of gender identity. That's the case.
So in other words, it's a matter of the text of a statute, and it comes down to one word above all else.
That's right. What is the meaning of sex? It's a big word. It's a loaded word, as we all know. And ultimately, it's a tough call. I wrote a piece in National Review. I'm still sort of scratching my head about which side is right. Ultimately, it was a 6-3 decision with Justice Gorsuch and Chief Justice Roberts joining the liberals, holding that Title VII does include protections against discrimination on the basis of sexual orientation and gender identity, because the word sex includes all these considerations. If sexual orientation as a matter of same-sex attraction. Gender identity is whether you identify as the sex that you're marked down on when you're born. These things, not necessarily what people were expecting when they legislated in 1964, but this is not a matter of legislative intent or what those on the left tend to like the purpose of the statute. Forget the text. What is the purpose of the statute? No, it's not that. It's this word sex, which can be read, and indeed Gorsuch for the majority says is best read to include these other aspects of sexuality. And in dissent, there was the three in dissent were an opinion by Alito joined by Thomas, and then a separate dissent by Kavanaugh. Alito said, well, you're getting a little too cute here, because even if someone is being fired because of their same-sex attraction, the boss can have a policy and fire someone without regard to knowing what their sex is. Say you have someone named Chris or Sam or Pat, and this person would be fired if they were gay, regardless of whether if they were male or female, and this person would not be fired if they were straight, regardless of whether they were male or female. And so that's the straightforward way of reading that. And Justice Kavanaugh, I think this is ultimately the decision that I feel most close to. He basically says Gorsuch's textual reading, they're all textualists. We're not arguing from different kind of, what are our values or what have you, or what should be the policy. But Kavanaugh says Gorsuch is being too literal. That is, you're supposed to read the statute, the text, for its ordinary meaning. And even now, even in our enlightened progressive 2020, if you wrote a statute saying on the basis of sex, you would mean sex, you would mean male, female. You wouldn't include sexual orientation, gender identity. Those would be more specific terms. You're basically ripping this out of the political branches. But that's what we have. And again, this is a statutory case. And it was a closer case than either side made it out to be.
So let's take a step back here. You've mentioned textualism and textualists a few times. For those who may not have studied anything about the Constitution, what does that mean about or Constitution or the law? Because this is not about the Constitution. What does textualism mean?
Textualism is simply applying the text. 30, 40 years ago, judges would only apply the text if the purpose of the statute was unclear. I mean, it's all backward. They use the text to illuminate the meaning or to illuminate the purpose of the statute. Now, through this is perhaps even more than with originalism, this is one of Justice Scalia's and Robert Bork's big contributions, is that we actually care about the statute. Certainly conservatives do, and even someone like Justice Kagan has used the tools of this trade. And so it's slightly different than originalism. Again, there are different background presumptions because Congress can change statutes, Congress cannot change the Constitution. But the idea is you're trying to get at the best meaning of what the text on the page is. And Gorsuch basically says, look, this might be a crazy result. This might be a surprising result. But I'm going to hold Congress to the letter of the law. And if they don't like it, that's fine. Just change that law.
Again, Ilya Shapiro at the Cato Institute is our guest here on Jimmy at the Crossroads. So I want to read a snippet from Alito's decision that has caught particular attention, where he said, Justice Alito, the court attempts to pass off its decision as the inevitable product of the textualist school of statutory interpretation championed by our late colleague, Justice Scalia, but no one should be fooled. The court's opinion is like a pirate ship. It sails under a textualist flag, but what it actually represents is a theory of statutory interpretation that Justice Scalia excoriated, the theory that courts should update old statutes so that they better reflect the current values of society. And he's particularly citing Scalia because Scalia is perhaps the most renowned textualist ever to sit on the Supreme Court and one of the most renowned legal scholars of textualism that we've had in our country's history. What do you make of that particular aspect of Alito's dissent?
Yeah, I think that would have been better aimed had that opinion been written by Justice Ginsburg. Indeed, updating with policy preferences or with what a better reading is or something like that. Because I don't think that's what Gorsuch is doing at all. You can disagree with him on your understanding of the text, but I don't think it's accurate to say that he's not being a textualist, which is why I prefer Kavanaugh's dissent to Alito's. On the Scalia point, by the way, there's a bit of irony here because in 1989, Justice Scalia wrote an opinion called Oncale, O-N-C-A-L-E. It was a unanimous Supreme Court opinion reading a sexual harassment statute for the first time to apply to male-on-male harassment, which everyone knew was not the purpose of the original statute. I don't remember the specific language, but anyway, this was Scalia in effect not bending, but being a good textualist and reaching what my colleague Walter Olson has called surprise plain meaning. And so, everybody would want to, of course, invoke Scalia in a textualist debate. But as I said, this is not so much about Gorsuch being a bad textualist as whether he's being too literal and taking the words out of the context in which they might be and what they would mean either in 1964 or even now.
So in terms of this decision, how significant really is it? Because it's dealing with one particular statute, it's dealing with one particular word in that particular statute, Ilya Shapiro.
Well, about half the states, maybe just under half, already had their own statutory protections for sexual orientation and gender identity. So it's not changing the law in the entire country, for one thing. For another, most big companies, even in states that don't require it, have already adopted such policies as well. You've heard of woke capitalism or woke corporations. Certainly the big companies already have that as well. And most small employers probably do as well. Couldn't care less one way or another. Where it really would affect is some that might have religious objections, some that just will get sued. They're not making a decision based on somebody's sexual orientation, but the person being fired or demoted or not hired is gay, and they're going to have to spend all this money proving that the decided to take that decision because the person was not performing well or somebody else was better or what have you. So it does kind of generate more income for employment lawyers. And then you have collateral effects. And this is something that Alito pointed out and made the servers of the Supreme Court, when everybody download this opinion, he appendices all these forms of federal government forms and other federal laws that use the term on the basis of or because of sex that will now potentially be litigated and potentially have these other protections read into them, which could open up litigation, including in things like women's sports or other areas of law that go beyond employment discrimination. But that's not a direct result that is yet to be litigated.